Good afternoon. We are at the end. Welcome to panel 6, which will address the issue of sustainable development in a dual perspective, if I understood, focusing on international rules on the protection of human rights and the environment, including in economic terms, and the national consequences of those obligations may be the implementation at EU level. First of all, allow me to thank the colleagues, Alessio and especially Paolo Fara, who organized this event. And okay, no problem. And I greet the brave who have faced the scorching temperature of Sicily to be present here in Messina, in spite of those who still deny climate change. I would like to begin with by saying that the topic of the conference is emblematic of the complexity of the issues of our times. Economic liberalism, as we have not practiced in recent decades, is not only anachronistic, but I think it has jeopardized decades of struggle to assert the protection of human rights and the environment. On the other hand, the call to ecology that should inform the policies of the states, of each state in the Anthropocene area, risks remaining without content, almost an invocation of principle, a little like philosophers. My opinion is that never before would we really need good philosophers to help us overturn the pyramid of dominant ideas or imposed ideas for the achievement of short-term result of some politicians. The protection of the environment and the protection of human rights must be considered as a basic element on which to build economic, energy, and climate change mitigation policies. Instead, these parameters are all invoked exceptionally. I very much hope that the following reports, the following papers will provide us with further information so that we can continue to hope for a reversal of national policies. And the first paper itself sets the ambitious objective of responding to one of the most controversial and divisive questions in international law on environmental protection, namely the value and content of the right to development in postmodern international law. I gladly give the floor to Michele Crisafulli, he's a PhD student at the University of Messina, reminding him that he has 20 minutes to present his ideas. Thanks, Michele. It's a pleasure.
Okay. Hello, everyone. First of all, I would like to thank the organizers for this opportunity. In this presentation, I would like to answer one of the questions of this conference. When it started with the call for paper, one of the questions was, is there a right to develop as well as a right to undevelop? Okay, so I would like to start with the definition of the right to development as a human right. The right to development was defined as a human right by virtue of which every human person and all peoples are entitled to participate in, contribute to, and enjoy economic, social, cultural, and political development. This definition was given in 1987 by the General Assembly of the United Nations. So 40 years later, almost 40 years later, we are experiencing a lot of environmental issues. So the question is simple: what went wrong? The main problem of our development is linear economy. Linear economy is based on 4 moments. The first moment is take. In this moment, companies takes raw materials. The second moment is make. Companies transform these raw materials into products. Third one is use. Consumers buy and use the products. The last one is dispose. Consumers toss the products out, creating waste. Which are the limits of LE? First limit is that LE's goal is only to obtain a revenue. Second limit is that it doesn't take care of the types of material used and how that material can be reused. Third limit is that raw materials can be used just one time. The model of linear economy, it's a failure because it's based on 2 false assumptions. The first one is that it works only with a limited supply of natural free of charge resources, and that is not true. Second false assumption is that it works only with a limited capacity of the environment to absorb pollution. Also, this assumption is clearly wrong. In fact, science demonstrated thus that unchanging world population growth and resource consumption, the condition of humanity will change dramatically within 40, 50 years, also less. So, in the age of the Anthropocene, what institutions and individuals can do? I would like to suggest 3 strategies. The first strategy is the recognition of a general right to undevelop. I try to give an hypothetical definition. It will be defined as an individual and collective right to require the reduction or the cease of development to save the environment and to protect the human beings from the negative consequence of their own actions. There are some threats of this strategy. The first problem is that it will grant immediate results, but restricting economic initiative will not be a permanent solution. Second problem is that it will be difficult to establish generally how, when, and which development should be reduced or stopped. Third problem is that right to development is strictly related to the concept of economic freedom that finds a strong law protection. So in this hypothetical balance, it will be really difficult for the right to undevelop to win against economic initiative. Let's move on to the second strategy. The second strategy is to recognize the right to undevelop as a balance between right to development and protection of human rights. In this case, the definition will become individual and collective right to require the reduction or the cease of development each time it affects human rights. In particular, the right to clean, healthy, and sustainable environment. The consequences will be the following. The courts should create the criteria to make this balance possible. So climate litigation will become an instrument to enforce or enhance climate commitment made by governments. We are experiencing this situation. In fact, in the last year, the growth of climate litigation is clear. I would like to speak briefly of the case Urgenda versus Netherlands. This is a leading case of climate litigation because in this case, in all 3 court instances, the judges recognize the inaction of Netherlands. climate inaction of Netherlands, and they ordered the state to limit the volume of Dutch annual greenhouse gas emissions by at least 25% at the end of 2020. This case is important because the courts gave answer to three important legal issues. First one is individuals and organizations can sue the states to enforce climate inaction. The answer of the court here is simple, because in Netherlands, the law established that a foundation can protect public interest against the state or against private persons, such as multinational companies. The second issue is the fact that the court obliged the state to reduce greenhouse gases emission can be considered a violation of the separation of powers. The court answers that the state was violating human rights protected by European Convention on Human Rights, and this is enough to permit the judicial power to oblige the state to prevent all these violations. The third issue is, which is the legal basis of the obligation? Here the court found this legal obligation in Article 2, right to life, and Article 8 of European Convention on Human Rights. The court said that these two articles protect also environmental related situations. So the conclusion is simple. Each state is obliged to do its part to prevent climate change. The second case is our national case, Giudizio Universale. It started in 2021. Here, the requests of the claimants are to declare Italy responsible for its inaction, and also here to order the state to reduce the emissions. We are at the very beginning of this case, so it's difficult to predict what the Italian court will decide. This second strategy has some strengths because it grants a detailed analysis of the different situations in each state, because it's the court that decides. It represents also an effective form of subsidiary protection. There are also some problems because it works only with an ex post perspective. It doesn't take into account that the concept of economic growth, environmental protection, development, and protection of human rights cannot be considered separately. The third problem is that each national court may decide differently. So the third strategy, I think, can be the more effective one, is the recognition of a binding right to a sustainable development. So what is sustainable development? It's a development that meets the needs of our present generation without compromising the ability of future generations to meet their own needs. This definition was given in 1987. Sustainable development is also a development that respects the rule of the three E's. The rule of the three E's says that a development is truly sustainable only if it puts together economy or environment, ecology, and equity. So it's the point of meeting of these three areas. For the first area, economy, a sustainable economy is management and use of resources to meet household and community needs. The main instrument to achieve the sustainable economy is circular economy. Circular economy is a model of economy in which raw materials can be reused, recycled. So at the end of this process, we have only residual waste that can be absorbed by environment. It's important to underline the relationship between CE and SD, circular economy and sustainable development. I think that the most effective definition is that one that considers this relationship as a subset relationship. In fact, CE is one of the tools for sustainable development. Second area is ecology. Ecology refers to the relationship between humans and the environment. it is important to protect the natural production of resources and the attitude of nature to absorb waste. The third area is equity. Equity is fairness. It has two meanings. Intragenerational equity, that means that people of the same generation have the same dignity and the same rights, and intergenerational equity. That means that people of different generations also have the same rights. So, what institution a legislator can do? They should create SD-oriented regulations. For example, Agenda 2030. This resolution embodies a comprehensive vision of development consisting of economic, social, environmental dimensions. The problem is that it's not legally binding. In Europe, there is the project of European Green Deal, that is a series of proposals adopted to make EU the first climate neutral bloc by 2050. The revolutionary aspect is that the Green Deal aims to enforce legal obligation in this area. In Italy, we have Piano Nazionale di Ripresa e Resilienza, PNRR, that establishes 6 missions that involve all the aspects of Agenda 2030 and sustainable development. So, the challenge for the next years is to reform our regulatory system in order to delete the separation between economy, ecology, and equity that law still largely keeps. A legal comprehensive system is the only way to grant a by design transition to SD model. In the last part of my presentation, I would like to underline the importance of a top-down strategy. So we have seen what institution a legislator can do, but it's also important the action of individuals. This is a private law perspective. The first idea is the idea of a sustainable contract. With this idea, the contract changes its traditional function of exchange or circulation of individual goods to that of shared enjoyment and management of common goods. So with this idea, the contract has to lose its purely asset-driven connotation, becoming an option for generating economic utility that is not strictly ownership-based and is compatible with the full development of human beings. The second idea is to use SD, sustainable development or sustainability, as an interpretation criterion for contracts and laws, such as the bona fide criterion. So the advantages of these strategies will be that it will promote a decentralized model of sustainability standard. It will make people more responsible for their choices, and consumers will express in their transaction not only their economic interests, but also non-economic values. So, in conclusion, I think that my answer to this question, is there a right to develop as well as a right to develop, is that it will be utopic trying to recognize a general right to undevelop. The right to undevelop as a balance between right to development and protection of human rights is a good subsidiary protection. And the recognition of a binding right to sustainable development represents the best long-term strategy. Thank you for the attention.
Thank you very much for sharing your ideas with us and for reminding us of the importance of that principle like solidarity, subsidiarity, and sustainability, if correctly understood, can advance this world rather than drive it back in time. We now move on to the second paper, the second presentation prepared by two Russian people, colleagues, Daria Boklan and Alexander Solzner.
This one.
Excuse me for the pronunciation.
Sunny.
Okay. Daria Boklan is professor of international law and international economic law and international environmental law at the Eiger School of Economics of St. Petersburg. Moscow. It's in Moscow.
University.
Okay. And I particularly welcome to Italy and Messina in the idea that we must never interfere in the dialogue between us, and dialogue discussion, I think, is the only way to advance humanity. Please, Daria, if you prefer, this one, maybe it's better.
Marcella, thank you so much for such a kind presentation of myself, and because it's very important for Russian scholars to have this hope that we can still have cooperation, connections, regardless of what we are blamed for and what we are responsible for. It's a different story, but I won't like to go too deep and to discuss this, but the only thing that I would like to say is deep and great thanks for you for letting me present today and for not breaking these connections, because cooperation between international lawyers in this specifically tense times, especially for Russians and Ukrainians. Actually, I'm half Ukrainian, half Russian. Therefore, half of my family is in Ukraine and other half is in Russia. Therefore, it is the only way for me to overcome this situation. And there are many people like me, a lot of people like me, and especially for international lawyers from both countries, to have this possibility to discuss and to have hope that these discussions will lead to improving of this tense situation. And moreover, I would like to say that the topic of our today's conference could be regarded as a tool that can unite different countries with opposite opinions and can contribute positively to overcome existing crises in international relations. And speaking on behalf of our interest group on international law, being one of the co-conveners of this group, I would like to focus on a specific topic. Yes. Okay, thank you very much. I see. Good, thank you so much. And address a very specific issue, answering the question, could morality exception from trade liberalization, legal regime, contribute to environmental protection? So current practice of states and of international tribunals reveals increase of interconnection between human rights and environmental protection. And last year adopted resolution, actually mentioned by my colleague, adopted by the United Nations Human Rights Council, from the first time in history provided the human right to clean, healthy and sustainable development. That is the first instance in the history of human rights, as well as in the history of environmental law. And also this resolution calls upon United Nations member states to implement these rights into their national legislation. And this fact leads us to the assumption that environmental protection could be considered as a public moral value as soon as it is considered as one of the human rights. And it's also could be considered as an anthropogenic approach to the environmental protection, because humans again are in the center of the issue, and that is again shows that this the environmental protection could be considered as a moral value, as a moral concern. And here we have the WTO law, which provides for trade liberalization, and alongside with that, it provides for exceptions from this trade liberalization, meaning general exceptions, two of which are specifically focused on environmental protection, and one is specifically focused on protection of public morals. And if we agree to consider environmental protection as one of the public morals, we can add one more possibility to justify inconsistent measures, like trade bans, for instance, by invoking morality exception. So on the one hand, it's a good additional tool to protect environment using trade norms, but on the other hand, this tool may lead, this eco-considerate interpretation of trade notion and of trade provision would lead to interference of one WTO member using morality concerns into the domestic affairs of the WTO member. And such interference may be in different spheres of internal affairs, including economic, sociological spheres, political spheres, even religion. And this approach may be seen as an attempt to engage in so-called cultural imperialism. This is because morality exception could be abused and could be used as a protectionist weapon by WTO members. So the question I would like to raise in this presentation are two, and there is the following. First one, whether the respondent, meaning the responding of the WTO dispute settlement body, could invoke the existing morality exception to justify WTO inconsistent measures taken to enhance environmental protection. And second, if the answer to the first question is positive, what are the challenges and risks associated with such an invocation? So starting answering to the first question, the principal concern is the extent to which countries may use already stretched morality exception. Under Article 20 and 1420 of the GATT and 14A of the GATT, this provision provides a justification of a WTO inconsistent measure if it is considered necessary to protect public morals. Most of the bilateral and regional trade agreements, including mega regionals, they replicate this provision, meaning that most of trade regulating instruments contain such possibility to justify trade measure inconsistent with trade liberalization to justify it with public morality exception. However, none of them provide any clarity on the content of this provision, namely the content of public morals. The definition of public morals is absent in all of these agreements, including WTO agreements. Neither of them provide the definition of public morality. And that is the problem which WTO dispute settlement body tried to resolve. And in one instance, that is ECC products case, and the other instance, the US gambling case, the panel specifically underlined that the term public morality may vary over time and space, depending on various factors, including prevailing social, cultural, ethical, and religious values. And later, appellate body added that the state has the right to determine the appropriate level of protection for its public morals. And further, in 2 years, this approach was reinforced by the panel. And the panel stressed that the members must be given a certain degree of policy space to define their own public moral objectives, as each member may have its own concept of morality. What does it mean? It means that each WTO member has a discretion to define a public morality. And it's totally subjective matter of WTO member to define what is public morality according to its own scales and interests. Meaning that it's a possibility to abuse and to define as a public morality anything under the sun, and to use this exception as a protectionist weapon. According to WTO practice, public morals vary from religion, human rights, consumption of alcohol, drug trafficking and corruption, gambling, consumer protection, to protection of animals. So you can see that it's a variety of different issues that already have been included and have been considered as public morals. In addition to that, there is no need for the respondent to show an imminent risk to environment to invoke public morality exception. Therefore, again, we see that it's a total discretion of the respondent to define public morality, and it makes it like we can compare this provision with a Pandora box, which could allow any WTO member to justify actually any measure as a public morality concern. This approach means that environmental protection can be considered as a public morality concern and can be invoked by the respondent to justify WTO inconsistent measure, meaning that the answer to the first question is positive. It is possible to invoke morality exception to justify a measure aimed at environmental protection. However, this approach has several counter arguments, and I would like to focus on 3 of them because there are more. First is that environmental protection is not merely a moral but also a market concern. That is not my personal position. This argument was put forward by Mavrodis, who analyzed a measure. Mavrodis, Greek, yes, Greek family name, who analyzed the measure which was applied by EU in EC seals case. That was a ban on seal products, and the scholars considered this measure of EU, at least part of this measure, as an industrial policy measure, but not purely social measure. And he submits that Article 20 of the GATT cannot cover measures of industrial policy kind. So this article is designed specifically for purely social, non-trade, non-economic interests, for protection of such interests. And if the measure could be considered, could be regarded as industrial policy measure, it cannot be covered by a morality exception. And it is very likely that most of the measures which are aimed at environmental protection at the same time could be regarded as industrial policy measures as well, because natural resources and economy are closely interconnected issues. Therefore, there is a risk of such a destiny of the measure aimed at environmental protection to be considered as industrial policy measure, and therefore to fall out of the scope of Article 20 of the GATT and Article 14A of the GATT. Second risk is not meeting, I'm sorry, that is the citation from the Mavrodis paper, and he says that if we were to understand public morals as encompassing industrial policy, then the whole GATT edifice would collapse, because this article was not designed for industrial policy protection. Second risk is satisfying requirements of the chapeau or introductory clause of Article 20 of the GATT, which requires that the measures shall not be applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination between countries where the same conditions prevail, or a disguised restriction on international trade. It is very likely that the measure aimed at environmental protection and invoke as a public morality concern will face the same difficulties as the measure imposed by the US faced in US shrimp case. First, the respondent might be accused of forcing other WTO members to adopt environmental standards similar or just same as its own national standards. And second, it would be burdensome or perhaps impractical in current nationalistic and protectionist relations within the WTO, the crisis within the WTO, for respondent to mutually negotiate with WTO members such kind of standards, concluding the agreement. It is very unfortunately unlikely in the present conditions. And taking into account that chapeau in all 7 cases when the respondent tried to invoke Article 20A of the GATT to justify WTO inconsistent measure was not pleaded successfully. No instance of successfully passing chapeau of the GATT invoking morality exception. Taking all these facts together, it is very unlikely that measure aimed at environmental protection will pass the test of the chapeau. And the third possible challenge for such measure is so-called jurisdictional issues, meaning in particular extraterritoriality of an eco-responsive defense. So the problem is that provision of morality exception doesn't define whose morals can be protected. And if EU citizens could have legitimate moral concerns about how Norwegians and Canadians hunt seals in Norway and Canada, can, for instance, the US government claim that US citizens have legitimate moral concerns about rainforest utilization in Brazil or CO2 emissions in China? So in case we use such approach, we agree to impose extraterritorially national legislation of WTO member to the territory of the other WTO member. Therefore, the issue of this presentation is a double-edged sword. On the one hand, eco-responsive approach to regulation of trade should be definitely supported. But on the other hand, environmental concerns should not be used as a tool for so-called cultural imperialism, which even possesses a risk to make the current crisis even deeper. Alongside with that, nature will not wait till states will resolve the crisis in international relations, and could be on the opposite, could be the platform where the states can find mutual solution in resolving environmental problems, regardless of the fact that they are in opposition with respect to different issues, not connected with the environmental protection. What solution could be used to find this balance between abusing, using this possible justification of environmentally oriented measures and really protection of environment? In my opinion, there are two possible solutions. Both of them are connected with a way of interpretation of international law. One is so-called systematic interpretation, when the court, for instance, or a state interprets a rule or definition from trade or other economic instrument in the context of ecological or environmental treaties. And another way is, or in addition, is to use so-called evolutionary interpretation. For instance, taking into account present conditions of climate change as a fact, we have to consider to interpret the term evolutionary. For instance, air already was considered as exhaustible natural resource within the WTO in US gasoline case. Therefore, climate as such could be theoretically considered as exhaustible natural resource as well. That is the example of evolutionary interpretation, as well as sea turtles were considered as exhaustible natural resource, also using evolutionary interpretation. And also systematic interpretation when we look at WTO law in the context of environmental agreements related to particular dispute or to particular issue which is under consideration. So I believe this could somehow contribute into environmental protection. Thank you very much for your attention.
Thank you. A lot of questions in this panel, I think. Maybe the discussion, some question. Thank you for sharing with us your study, your personal reflection, only about also about the war and the problem, the consequence of the war. I'm some doubt about the potential risk that some exception may have in economic relations. Because maybe it's possible to perceive this like the risk, but it's also important to underline that in some country there are some values founding of democracies. Public morality or public moral is a problem is the definition of what kind is public morality and what kind of exception may be considered under the Article 20 of the GATT or the GATS. But the problem is more complicated, and maybe the two solutions are the solution. So the use of interpretative rules and the systemic interpretation under Vienna Convention of the Law Treaties. Now I think there is a debate. So the question, please, if you. Yes. What's the requirements? No. You have to move. Oh yes. Okay. Okay. No problem. This is your.
Oh, I can see
okay.
it.
Yeah. But you have to sit. No, I have to
Sure.
sit. No problem. Sicilian welcome.
Thank you. The Indian won't allow me to stand.
No,
Thank you.
no problem.
Thank you. Thank you, guys. I just want to start by thanking, is it Michele? Michele. Thank you very much for picking this topic up, because I won't be modest, and I will tell you that I wrote that particular clause in the call for paper. So it's really nice to see that you actually ran with that and gave some ideas. I just want to pick up.
I started my research, so.
Yeah, no, that's really excellent.
Okay,
because it is, you know, right to undevelop is not actually such a famous concept, and you actually tried to define and find a conception for it, which I think is a very good first step. But I'm going to ask you a question more about the usual. So I want to pick up on your example that you gave, or rather the optimism that you seem to place on the Urgenda case, right, the Dutch case. And you talked about, so my question is, do you think this is setting a trend for establishing human rights as a valid defense for climate policy that is designed for 1.5 degrees C? Or do you think it's just a one-off? The reason why I'm asking this is because, and I want to indulge a little bit in comparative law here, the UK Supreme Court has come up against this. The UK Court of Appeal, which is the lower court to that, also came up with this, but they assiduously avoided getting into the area of human rights. And so this is a case where Heathrow Airport in London was going to be expanded. It was for a third runway, and it went through the ports, and it's gone through up and down. The Court of Appeal decided that the government was actually in violation of its obligations, but the Supreme Court then reversed it. But then the reasons they gave were not because they engaged with human rights. They actually avoided it. They took the decision on administrative grounds. Hence my reservation about whether the human rights argument is going to be replicated around the world, and in particularly in jurisdictions that really matter. And why am I saying that the UK matters? It's because if you look at the emissions, EU as a whole contributes to 9% of the emissions in the world, greenhouse gas emissions, and UK by just itself contributes to 1% of the world's emissions. So that means the country that does matter and does set a trend. So that was my question to you. Daria, thank you. It's always just wonderful to listen to, you know, analysis of WTO jurisprudence, because WTO jurisprudence is kind of a tightly structured legal dance, and so it's very interesting to see it as you know, navigate through 20 and the particular subsection in 20, which is morality. I've been myself looking at another subsection of 20, the exhaustible natural resources clause. But with respect to 20, I was very curious about this extraterritorial eco-responsive measure that you talked about. Now, there's an objection. You know, why should I be concerned, or why should the panel be concerned for the morality of the third country, not the parties. So that's the idea, isn't it? And that's what's being raised. But just as a matter of coherence, I mean, the trade here, the natural resources are anyway in that third country. So if we are fine with extraterritorial natural resources coming in via free trade, why aren't we fine with extraterritorial morality concerns coming in as well? I mean, is that a blind spot, or is this kind of, you know, even kind of looked at all? Thank you. Thanks.
So I also thanks both the speakers. Daria, Chamo has already anticipated part of my question, so probably I will let you respond to Chamo. By contrary, for Michele, I was reading your paper. It's very interesting, the use that you do of contract law here. I was working on, I published a paper on indigenous people and traditional knowledge using contract law as one of the elements, with also other rules of law coming from commercial law, from secrecy law, other fields that help to create a sui generis solution for misappropriation of intangible cultural heritage for indigenous people. So when I was reading your paper, I was thinking, it's trying to apply contract law on an area which generally you do not immediately connect to sustainable development. And by contrary, it is indeed an interesting attempt. So my suggestion is that the possibility for you to consider also outside contract law, other area, combination of constitutional law, contract law, and other sub areas that helps to make your argument on contract law even further, even stronger. No, but it is already very reasonable what you present. And I was reading the examples you did about green public procurements and also green franchising. I wanted to hear a little bit more your opinion whether these examples of this system actually work, because the main problem, I believe, it's whether those public procurement are asking for information prior granting the contract, but are they going to be monitoring it? Are they going to create a system of monitoring and transparency in the implementation of the actual contract, or is only at the moment of awarding the contract that this is happening? Because of course this is a big problem between what has been declared and what will be actually implemented. So whether there are monitoring system, reporting, transparency, whether this information is only provided to the governments or to the public authorities, or whether it's made available to the public, because what is happening many times is that you are ticking the box, right? If you're making them available to the public, then you can have onlookers, NGOs, civil society activists that would intervene to reveal whether this has been implemented correctly or not. But those are just suggestions. So it's an interesting perspective. And then regarding green franchising, you say, I mean, you report what Landini 2016 article referring to franchisor who has also provided their franchises with know-how in terms of reducing pollutant emission, and those codes of conduct require franchises to comply with certain ecological standards. Again, codes of conduct, are they implemented in a way that they are contractually binding? In that case, they are not codes of conduct anymore. They are actually something else. So those, I mean, I would have many more additional comments or reaction questions to you, but let's stop there. Again, thank you.
Any other question? Please. I'm quiet. Really quiet.
I need to leave something from Bocconi.
Yes. Yeah. So thank you for the presentations. My question is for Daria. In Article 20 of the GATT, there are actually two other exceptions that deal more directly with environmental issues. The paragraph B, animal or plant life or health, and paragraph G, conservation of exhaustible natural resources. So I was wondering, especially considering that we have these two exceptions that relate more directly to environmental protection, why your focus was on public morality instead of these two exceptions when it comes to the integration of environmental concerns to the WTO already? Thanks.
Thank you.
Thank you for your inspiring presentation. I have something to propose as topic of discussion to Michele. I really like your presentation. Also because in the considering our conference, our workshop until now, your position was a little bit different from other positions that we had during this presentation about the notion of sustainable development. And so my question, my proposal of discussion is about that, because yesterday we had a presentation which was stressed the oxymoric nature of the expression. In the sense there is a contradiction, there would be a contradiction between sustainability and development. Of course, this kind of position, as you know, are linked to the idea of development as a anthropocentric, liberal, neoliberal, and capitalist concept in itself. And so problematic for this idea, and so incompatible with the idea of ecology, sustainability, and so on. We also had presentation or position or intervention that show us at the end of the day the rhetoric of sustainable development is a new way for the classic neoliberal economy to create damages to undeveloped countries, because they need, in order to produce according to the criteria of reduction of pollution and so on, to use resources of other countries. And so, you know, there is we had this position, of course, in this workshop. It was obvious, considering that the workshop is on the relationship between liberalism and development. So I would like to know what you think about that. In which way you react to this kind of other position. But I would like also to stress a point, in my view, very, very interesting, inspiring of your presentation. In my view, but I don't want to suggest the answer to my question. In my view, it's one of the fields in which it's very interesting to work. Is your reference to circular economy? Because I think that this is the point, because your description of sustainable development is quite convincing, in my view, is solid in that theory, as long as it's linked strictly linked with the idea of circular economy. Because otherwise, the objection could be fine. But the point is that until now, the measures and the way in which the measures were adopted.
The problem is process or product.
Exactly. The problem is that until now, the way in which the measures linked to the programs of sustainable development were adopted didn't trigger a process of circular economy, but they were consistent with a traditional linear economy. And so with all the outcome that you put forward. And so in my view, your description is very inspiring and interesting. And if I can, I would suggest you to stress also in your research on the key role of the idea of circular economy in order to defend a possible understanding of sustainable development. Thank you very much.
Erika, the problem is the distinction from process to product. In the WTO, the problem is this. The WTO rule concerning only the product, the final product, not the process. And the problem in the sustainable development is the process.
Problem.
Yes,
That will be Thank you.
due diligence. Pero
I say. Thank you for the very interesting relations and interventions. I would like to make a strong question that is quite linked, I think, with what you said. What is the role of jurisdiction for the safeguarded environment? Because if we just think about the safeguard of fundamental rights, for example, actually it happens all over the world, like especially in Italy for other fields, like, you know, assisted suicide, all of that. The Italian Constitutional Court dealt with these problems in a very specific and efficient way because Parliament didn't do anything, and it was necessary that a safeguard of fundamental rights was represented, and there was the court which intervening for doing that. But the point is that we are facing a dramatic gap between what needs to be safeguarded, there is fundamental rights, and who should safeguard it, that is parliaments, or at international level. It's quite more complicated, but anyway, institutions and which don't do that. And I think it is connected with what we're talking this morning. There is the role of democracy and the role of political representation on that. So actually, what I think is my thought, but I would like to know yours, of course, is that jurisdiction matters. Jurisdiction can act, but it cannot only be the protagonist of all the process, because it's like if a person is ill, okay, the doctor needs to intervene to avoid it to die. But the point is that the person should never be healed, because you should prevent that person to be healed. So we cannot just only think about emergency, combating it with emergency, because when jurisdiction intervenes is a democratic and constitutional and international emergency, because there should be institutions who would have the role to solve these problems. So what's the balance between definitely jurisdiction and the safeguard of fundamental rights, specifically on the safeguard of the planet? And so what's the emergency of the emergency? So the emergency of the planet. So thank you. Right.
thank you, Erika.
No, comunque funzionava secondo me.
No? Thank you.
Ma non l'ho visto io.
Other question? There are a lot of questions, I think, for Michele. Okay. Michele, about the rights to development, we discuss when you want.
Okay. Okay, so I would like to answer to all these questions. The first question was about the possibility to recognize a trend of the agenda case for also other states. Uganda can be considered an example for other cases or not. In my presentation, I hope that it could become a trend, but I also think that it's difficult to become a trend. In fact, I've underlined the legal issues that I thought that they were the more difficult part to overcome to arrive to that solution. And I'm really skeptical that the solution reached in Argenda case can be reached also in other states like that. So I think that it's difficult to replicate in all the states that solution. So I hope it will become a trend, but I am really skeptical about it. So the second question dealt with the contract law. My aim was to underline the importance of individuals in this reasonment when we are because when we speak of environmental protection, we usually put the attention on institutions, legislators, but individuals with their own transaction, economic transaction, they play a central role in environmental issues. So in my paper, I'm giving some examples of sustainable contracts. For example, the idea of green franchising and also green public procurement. But the problem that Professor Farah underlined, it's real. That problem to make everything okay? The problem of the correspondence between what a contract says and how to make this statuation of the contract legally binding. So I think I have to study this theme because it's really interesting and it's a good point that has to be analyzed to overcome these difficulties, because yes, they are examples, good examples of sustainable contract, but the other part is the executive part. It's important that this contract becomes also legally binding. So I will study a lot about this part. So the third question was about the other vision of sustainable development as an oxymoric figure, like rhetorical figure. Well, I think that we have to try to have a practical approach. In fact, in my paper, I write that it's possible to measure as the sustainable development. It's possible to measure with a lot of instruments. For example, the most simple is the measurement of decoupling. For example, it's important to measure this concept of decoupling means that economic growth has to separate from environmental impact. So we can, for example, we can measure this value to understand if something is really sustainable or not. There are also some instruments that we can use to measure social inclusion and sustainable development for our society. So I think that is not only a rhetorical concept, it has also practical implications. So the important is our aim to give to this concept a practical relevance, but the instruments are present. So this is my idea and my hope. The last question from Erika. No, it's okay. They're all. No.
The time for reflection.
Yes, I was thinking. I was watching you think of your question. Okay, so the role of their jurisdiction, I think, as I said in my presentation, it's only a subsidiary form of protection, but it not represents the real protagonist of the main instrument to safeguard the human rights. So I think it has to have only this subsidiary role.
Thank you very much for very interesting questions. So starting with the first one put by Chamu, what is the difference between natural resources and public morals? So at least I would like to point out two different features. So natural resources, they may or can move through state borders physically, like sea turtles. Public morals cannot move through state borders physically. Therefore, there is a point to apply extraterritorially eco standards, like was in US stream case, to protect turtles which are moving through the state borders in the ocean, unlike public morals, which are not moving and which do not need this type of protection. And second, probably most substantive one, that natural resources is an objective issue. It's an objective object, if it's possible to say. So they're concrete objects and they could be assessed and described and defined objectively. We all can define sea turtles, or we can look at the biologist researchers encyclopedia and define what is sea turtles. Unlike with the public morals, they are absolutely subjective. It's not possible to find universal definition of the public morals. It's a discretion of a state to define its own public morals. That is a very substantive difference. We can compare public morals with essential security interests, which were interpreted by the WTO. Actually, that was again the case with Russia, Russia-Ukrainian case, Russia transit case, where Russia, for the first time in WTO history, invoked so-called security exception, and this provision was never invoked in the GATT and WTO history, because WTO members were afraid to invoke the only non-trade but political provision to justify WTO inconsistent measures. And that was the first case where the panel was forced to interpret what is essential security interest of a state, of a WTO member. And it agreed with Russia. However, it was initially the US position that it is totally subjective notion. It is not possible to give objective definition of national security interests, and it's non-justiciable provision, meaning that the panel cannot even assess this definition. It's total discretion of a state to define its own national security interests. The same story with public morality. Therefore, it's quite substantial difference between natural resources, which more or less clear what could be defined under the natural resources, and public morality, which is totally subjective issue. That is the reason why it is problematic to pass a shuffle test of Article 20 for public morality, invoking it to protect environment. As for the last question, you're absolutely correct. There are two paragraphs specifically focused at environmental protection, and I mentioned this at the beginning. Why do we need this additional option? Probably we don't need it because, as I tried to analyze, it's not efficient to invoke this paragraph A as a public morality. However, on the other hand, if we consider environmental protection as a public morality, it could be invoked. What is the difference? With respect to paragraph G, we have to submit that something is exhaustible natural resource. With respect to paragraph A, we don't need to submit that exhaustible natural resource exists. We just may justify theoretically a measure which is generally aimed at environmental protection. With respect to paragraph B, it is also focused on health, measures necessary to protect human, animal, plant life or health. Therefore, the respondent has to show the risk for health specifically. If we invoke paragraph A, it's a total discretion of the state to justify eco-oriented measure. It could be broad, and there is no need to show the risk for health. There is no need to submit that the exhaustible natural resource exists. And in this respect, it's easier to invoke paragraph A. However, and I have no time to discuss this, I think that it's very unlikely that the measure will pass necessity test, the same which we have in paragraph B, because it's also an issue, but it's a separate discussion. Don't have time for that. And as for the last Erica's question, first of all, I wouldn't say that we can invoke different provisions and environmental protection only when there is an emergency. Because the main obligation of the state is to prevent environmental harm, and it's obligation of the state, and we can theoretically find state responsible for breaking obligation to prevent when there is no emergency. However, there is a violation of this obligation to prevent. And role of jurisdiction, I totally agree that it's supplementary, meaning that we have different forums, each responsible for its own jurisdiction, WTO trade, ICJ general jurisdiction, but it laws for marine environmental protection. And this is good that we have such different options, and we can use them to prevent this possible emergency. And Article 20 also can be used for such kind of prevention, but not only in case there is emergency at issue and prevention. Exactly. Thank you very much.